state your name for the record.
Thank you, Vice Chair Campbell. My name is Matt Krause. I'm with First Liberty Institute. I'm here to testify on behalf of Senate Bill 10 and Senate Bill 11, and we are for both bills. And First Liberty Institute is the nation's largest organization dedicated solely to defending and advancing religious liberties in our country. And we're thrilled with Senator King and Senator Middleton bringing these great bills. Senator King, I thought, did a great job laying out the how we got to where we are, from the Lemon case to Coach Kennedy to where we are now. And I think it's really worth driving home that Stone v. Graham case in 1980 was a per curiam opinion. And as you know, a per curiam opinion means that there was not one author of that opinion. It was not one justice saying, here's what we think, here's why we think it. They just all kind of joined. And usually per curiam opinions are 9-0, 8-1. It's usually when there's a lot of agreement. This time it was 5-4. And so it was a very interesting set of circumstances that said Kentucky could no longer put the 10 Commandments up on their classroom walls. We've thought it was wrongly decided for a long time, and thanks to Kennedy versus Bremerton, we now have an opportunity to go back and revisit that. I won't get into too many of the details on Kennedy versus Bremerton because I think there's somebody in this room who could probably do a better job than I could on that. But suffice it to say, the big takeaway was that the Lemon test was thrown out. And if you want to know why it was so convoluted, why we needed to get rid of Lemon and replace it with this history and tradition test, we need to look at 2005 with the Supreme Court decision in Van Orden v. Perry, which allowed our Texas 10 Commandments monuments to stand. On the exact same day, the Supreme Court issued another opinion on another 10 Commandments display out of McCreary County, Kentucky. That display was just a piece of paper amongst a lot of other historical documents, and the Supreme Court came down and said, because of the Lemon test, we're going to allow the big granite monument sitting on state grounds to stand, but we're going to not allow this one document, this piece of paper amongst a bunch of other historical documents. That violates the Lemon test. It was convoluted. It was hard to understand. You didn't really know where the court was going. So now that we've gotten rid of that, we have the history and tradition test. And as you're about to hear, there's really nothing more historical or traditional in our country's history than the 10 Commandments. And so I think we have a lot of confidence that the courts at some point are going to say, this is constitutional, this is allowable under the history and tradition test. And you might have heard that Louisiana's law did get challenged and it got struck down. But what a lot of people failed to understand is that was one district court. There's a reason they filed that lawsuit in the Middle District of Louisiana and not the Western District of Louisiana. We're very confident that when it goes up to the Fifth Circuit Court of Appeals, that decision will be overturned. And it's also important to note that even though the Middle District of Louisiana, which has about 5 or 6 of the parishes in Louisiana, they're not allowed to put up the 10 Commandments, other parishes in Louisiana are, and they're preparing to do that right now. So there's solid legal ability, solid legal standing to put forth SB10 into law. In regards to SB11, as Senator Middleton was talking about, you did have that opinion in Engle versus Vitale in 1962 where the Supreme Court said you couldn't have this prayer at schools. Now, I want to distinguish it a little bit because now in 2025, the court is taking a much different look. Rather than hostility to the Establishment Clause, we're looking more favorably on the free exercise element of that First Amendment. And so with this new court, with the new makeup, I'm very confident that such a measure as SB 11 could survive constitutional scrutiny. And one other thing that I think is important to note is that SB 11, it's optional, right? In Engle versus Vitale, New York Board of Regents said you have to read this prayer every day. It's optional and all those kinds of things. But here it's purely permissive. And so I think what you're going to see is this new court with its understanding, with the history and tradition test, its adherence to more of an expressive free exercise approach to the law, you're going to see SB 11 on firm constitutional ground as well. I'm happy to take any other questions, but Senator Hagenbu, I thought you hit the nail on the head. A lot of times we talk about the status quo, and we think the status quo is no 10 Commandments in the classrooms. We think it's no prayer in the classrooms, but really that's a pretty recent invention in our nation's history. And in the law, you have the status quo ante. Let's go back to what the status quo was before this new status quo. That's what SB 10 and SB 11 are seeking to do, and I think it's good. I think it's right. I think it's legal, and I appreciate y'all hearing this bill today.